Hello, everyone, and welcome to our second online information clinic in our custody series. This one's going to be about court process. My name is Alan Benedict. I am an attorney at the National Network to End Domestic Violence, part of the women's law team. Before I started with women's law, I was in private practice. I worked as a legal services attorney, and I also did some work as an attorney for the child. So I've done a lot of family court, both custody cases and restraining order cases, along with divorces, child support, you name it. I've probably had some experience in it. So today we'll talk about how to get through the court process. Before I talk about how to get through the court process, though, I want to first touch on some instances where a court petition may not need to be filed. It doesn't, just because you're having a disagreement at current time doesn't mean that a custody petition has to be filed in every single situation. Filing a custody petition really makes the situation more adversarial. It forces the parties to take sides along with the witnesses and the family members. It's hard to come back from this place really to a place of cooperation. Once you're in adversarial mode and everyone is kind of trying to document evidence against one another, it makes the situation very stressful, and it can be difficult living with that kind of relationship on a day-to-day basis. And then also going through a court process where you're essentially trying to show that the other parent is not a responsible person and shouldn't be able to care for the child, and that you should be the primary caregiver. This is not really a good way to set up a cooperative parental relationship going forward. So if things are working out okay and you're able to communicate with the other parent, then maybe filing a court petition isn't the best option. Maybe there's some other solution that you could investigate, which we'll talk about later on. Also, if there's paternity is an issue, then you may want to think before you file a custody petition, because it's possible that when you file your custody petition, you could be waiving your right to contest paternity in the future. By asking for a judge to issue a custody order with this other person, which would also include visitation most likely, then really you're saying that you're agreeing that that other person is the father. And so if there's any question about that whatsoever, then you should probably talk to a lawyer before you file for custody. That way you're not waiving any right to argue against paternity if that is an issue. Similarly with child support, most often the primary caregiver would be the one who is going to be filing for child support. It doesn't necessarily mean that there's a custody order, and you may not even need to have a custody order to get child support. Being the primary caregiver may be enough in your state, and so you can go ahead and file for child support without filing for custody, because oftentimes they are two separate proceedings. But be careful though, because when you file for child support, oftentimes the other parent is going to go ahead and file for custody, or for more visitation at least, if not custody altogether. So keep that in mind. That happens all the time. And also with this, you could be waiving your right to argue against paternity, because filing for child support, you're asking for a contribution from the other parent. And so essentially you are agreeing that that other person is the other parent. So if you have an argument against paternity, then again, think about the pros and cons before you go and file, because you may not need to file for custody. You may just be able to go and file for child support, but you might be also in the process, you might be waiving your right to argue against paternity. Just something to think about. Another reason, like I mentioned before, that you may not want to file for custody may be because you have another parent who you're able to work with, and it's agreeable, and you can do exchanges, and you can figure out holidays, and you can figure out decisions about education and medical care and these kinds of things. If that's all workable, then you may not want to invite a judge or a court process, because, as I mentioned, it makes the whole process adversarial, and it can make things much, much more difficult going forward. Of course, there are going to be times where things are difficult already and you can't agree. In those cases, yes, you're going to need to file for custody or for visitation, to get the judge involved to make sure that there's an order that has to be followed. But if things are working okay, those are really, cooperation is really the building blocks of a successful custody arrangement. And so if you're able to do that without the court's intervention, then it might hurt more than it helps to invite a court into the equation. Okay, with that being said, there are times, as I mentioned, where you're just not going to be able to agree, and a custody petition is going to be necessary. Some of the times when you will probably have to file for custody would be if you can't agree on the custody and visitation arrangement. Parents who can't make decisions about where the child should live, what the visitation the other parent should have. Like I said, medical decisions, education, religious decisions, these kinds of things can all be dealt with in a custody proceeding if you're not able to resolve those questions between yourself and the other parent. So if you're having those problems, then you may want to think about filing a custody petition. In doing so, then you'd have a court order that would define the custodial arrangement, so that going forward, hopefully those arguments would be minimized. Another reason that you might need to file for custody or file a custody petition, would be if the other parent is not allowing visitation. There are times where usually it's the primary caregiver. They don't feel as if it's safe or appropriate for the other parent to have contact with the children. And in those cases, they might be withholding visitation or contact. If that happens to you, you may be able to contact the police and try to get them involved, but they're usually not going to do anything unless there's a court order that says that you're going to have visitation or custody on a certain date and time. So if you're being denied contact with your children, then the person who's, if you're being denied, then your only option may be to bring a custody petition and try to get a judge involved in a custody order or for custody or for visitation. There are also situations where one of the parents is taking or threatening to take the children away. It could be out of state. It could just be in the same state, but concealing the whereabouts of the child from the other parent. If that's a situation you're facing, then you may need to file a custody petition to make sure that your rights are established and that parent can't leave without giving you some contact, either through some visitation or custody or phone calls if they're going to move away. A judge will be the one to decide what's appropriate based on the best interest of the child, which we'll talk about later on. If you do find yourself in this situation, then you may want to check out our 4th online information clinic in this series, because we'll be talking more in depth about what your options could be if one parent takes or threatens to take a child out of the state, or at least conceal a child from the other parent. Okay, so now without further ado, we're going to get into the court process itself. First step when you're trying to get a custody order would be to complete and file a custody petition. You can access these petitions. There are usually forms in every state that you can use, and you can access them either through the court clerk's office or sometimes online. It depends on the state, but more often than not, you'll find them with the court clerk. When you are filling out your petition, you're going to have to include the names of the parents, the names of the child or children, the addresses of the parties, your reasons for filing for custody, and also what you'd like the court to do. What is the end result that you're looking for, which is called the relief that the court can grant. When you're filling out your address, I realize some people may be fleeing from abuse and may be trying to keep their address confidential. It's possible that a court may allow you to do that. Just ask the court clerk if it's possible to leave your address confidential. Another option could be to sign up with the address confidentiality program in your state. You can usually Google address confidentiality in your state, and you should find some information about how to get involved in that program. So it may be possible to do that. Once you've completed your petition, that can be either on your own or with the help of a lawyer or maybe an advocate at a domestic violence organization. Then you'll have to go and file that petition. We do have more information about both completing the petition and filing the petition on our womenslaw.org website. So if you click, let me show you here now. If you click on preparing for court and then starting a court case, then there's some information about drafting and filing your petition, along with other information that could be helpful as you go through the process. All right. So when you do file your petition, most likely you'll have to do it in person at the courthouse. Some places do allow folks to file online, but there's no guarantee that's going to happen. You could call the court clerk and see if that's an option for you. And of course, with the ongoing pandemic, some courts are getting more into online filing, but chances are you'll have to go and file in person. And there may be a filing fee as well. In some states, there is a filing fee. In some states, there's not. And even if there is a filing fee, it's possible that there could be a fee waiver that someone could qualify for. This is, again, is something you can ask the court clerk about when you go in to file your petition. If it's an emergency, then the court, when you file your petition, the court may have a hearing that same day. And they could issue a temporary order ex parte, which means without the other parent or the other party present. If the judge thinks that that's appropriate, then it's possible that happens. But this is only when the situation is really, really desperate and it's an emergency. Like if you file and say that the other parent has threatened to take the child out of the country and never return, then you may be able to get the judge to grant you custody that's effective immediately, in which case you would be able to go and retrieve the child and prevent the child from leaving the country. That's in a minority of cases. Oftentimes what will happen is the court will put a date on the calendar that's a few weeks or maybe even a few months out. And then there will be potentially hearings or conferences along the way. And if there's no resolution, if the parties can't agree, then there may be a trial on that day where the judge would look at the evidence and make a decision, which we'll talk a little bit about as we go on here. So let's see, once you file that petition, the next step is going to be to have it served on to the other party, the other parent. Like I said, there may be a possibility that a judge could issue a temporary order. If he does that, then that also would have to be served on the other party, and they'd have a chance to respond. But that has to happen generally before the next court date or court appearance, or else it might have to be rescheduled so that the parent can be served, because everyone has a right to have information about the case before they're brought into court. You can learn more about service on our Preparing for Court section. As I showed you before, you go to Preparing for Court, and you can see here that we have some information about service. So if that's an issue in your case, then you may want to read through this, and you'll have some more information that might help guide you through the process. All right, so moving on, once the other parent has been served, then you'll typically have a few court appearances. There won't be trials or necessarily. It could be court conferences. So it might be a settlement conference where the judge would talk to the parties about the situation and explain how the process works. There are definitely variables and variety of ways that this happens depending on your state. I know at least in New York, it could be months or years before you had a trial. A judge doesn't necessarily want to have a trial. They'd like to have you reach an agreement if possible. So as I mentioned, in some cases, a judge could give you that temporary order while the case is ongoing. This can change along the way as well. So if there are changes necessary, so let's say the child wants to move to the other parent's house and the parents are in agreement, then the judge might change the temporary order to allow that to happen. If you have specific concerns about your child's well-being or your safety, you want to make sure that you mention these early on, either in your petition or in at the first appearance. That way the judge can address these in the initial order. And then if there is no decision or agreement reached, then the judge might have a hearing and make a decision for you. When the judge is making those decisions, though, they have usually a set of factors that they look to help them determine what is in the child's best interest. That's really the name of the game, is to hopefully have a custody order that is in the best interest of the child. And many states have a list of factors that the judge can use when they're deciding custody. These factors are called the best interest factors, and they'll vary from state to state, but there are some common ones that you'll see in most states, which we'll go through here. One of them is who's the primary caregiver of the child, who has been the primary caregiver throughout most of the child's life, where has the child resided for most of their life, which parent is better equipped to care for the child, which parent has a home that is most suitable for the child, does the child have any siblings where they're living. Judge really doesn't want to separate, usually doesn't want to separate children from their siblings if they're able to keep them all together. And then also, which parent is going to be most able to foster and encourage a relationship with the other parent. That's something that judges will consider as well. They don't want one parent who's going to demonize and exclude the other parent. They're hoping to have a sort of a joint relationship where the parents can both be involved, and where the parents are encouraging the children to go and spend time with or interact with the other parent. Of course, that's not going to be appropriate for all situations. If we're talking about an abusive situation, or if there's sex offenses involved, or drug use, or some other issues that make it unsafe or impractical for the other parent to have contact, then that should be addressed at the trial, and the judge, won't put as much weight on that factor as others. But in a situation where both parents are able and capable of having contact with the children, then a judge is going to look to see who is best at facilitating that contact. All right. So that's how a judge would make a decision. Let's talk about some of the other folks who are going to be involved in the custody proceeding. You may have an attorney for the child or a guardian ad litem involved. In some cases, the judge is going to appoint these folks to represent the children. Because, as I mentioned, the children, at the end of the day, it's the best interest of the children is what the judge is trying to account for and make a decision based on. So these folks who are representing the children could be called attorney for the child, it could be a guardian ad litem, depending on your state, and the role might be slightly different for each. A guardian ad litem is going to be someone who's stepping in the shoes of the child and then making decisions on behalf of the child based on what the guardian ad litem thinks is in the child's best interest based on the overall situation. Whereas an attorney for the child is actually representing the child or the children and talking with them as if they're, the attorney's clients, and then advocating for their position, even if they don't agree with that position necessarily. So there's a little bit of it's a little nuanced. There's a little bit of a difference there between the two. But at the end of the day, they are representing the children and advocating for the child's best interest most often. They function as other attorneys would, as the attorney for the mother and for the father, or for the parent and the other parent. They can call witnesses. They can present evidence. They can cross-examine other parties' witnesses the same way that the parents' lawyers would. And the judges often lean pretty heavily on the position of the guardian ad litem or the attorney for child, because they're actually speaking with the child. They're interviewing the child. They know what's on the child's mind, and they know sort of the backstory of what's happening here. And so the judges will listen to them and oftentimes follow their recommendations. Another person who could be involved in the court case could be the social worker. A judge can involve a social worker from Department of Social Services or Department of Human Services, from a nonprofit organization, or maybe the court itself employs social workers. That happens as well. So your social worker in your case will probably interview both the parties. They might do a home visit, conduct a bonding study with the child and the parents. They could speak with the child or the children. and then they'll draft a report based on their research and just outline their findings and recommendations for the court. The parties could then they could call them as witnesses and question the social worker about their findings and about their report. The report is going to be on file with the judge, and so the judge is going to be able to read this and use that as they're making a decision about what's in the child's best interests. There could also be a forensic psychologist involved in your case. Usually the forensic psychologist will do what's called a forensic evaluation, where they'll interview the parties and the child, and then they'll put together a report and recommendations based on their findings. Make sure, if this happens in your case, make sure you prepare with your lawyer to understand how best to frame your concerns and your feelings about the other parent. And also make sure you don't coach your child or your children. If there's a forensic psychologist, or even if there's a guardian ad litem or attorney for the child, you want the child to be able to go in there and just explain the situation free from interference from the parents. If the psychologist thinks that the child has been coached to provide certain answers, that will look negatively on the other parent, or the parent that did coach the child. So just let the child go in and talk about whatever it is that they would talk about without your intervention. And then again, as with other people who are submitting reports, you may be able to call this person to come and testify about what it is why they made the recommendation that they made, and what their thoughts are on the situation. Could also have a parenting coordinator involved. These are usually professionals who work with the parents to figure out appropriate custody arrangements or to resolve some minor disputes that might come up once an order is in place. Courts will sometimes use these folks to figure out the details of the custody arrangement. It's just easier for someone like a parenting coordinator to go through the nitty-gritty details about times for exchanges at holidays, kind of thing, as opposed to having a judge deal with it. And then if the parenting coordinator can make those recommendations to the court, or if they reach an agreement with the parties about these details, then that can be submitted to the court and turned into an order. That's similar to what a mediator might do if there's a mediator assigned in your case. Sometimes once you file your petition, the court might even require mediation before the case can move forward. Mediator's supposed to be an unbiased person who hears both parents' positions, and tries to work out an arrangement that would work for everybody. So, obviously this doesn't always work out, especially if there's a history of abuse or domestic violence. You may be able to ask the judge to waive mediation, but they may still require it. And they may say, well, you can do shuttle mediation, which is having the parties in separate rooms, and then the mediator goes back and forth and will say, this is what the other parent wants. Is this okay? And if so, we'll move forward. If not, I'll go back with a counteroffer, and then just going back and forth to see if there's some way to reach an agreement. If there is, then the mediator will draw up some documents and submit them to the court, and the judge can turn that into an order if the judge thinks it's appropriate. If there is no agreement reached, then the case can move forward towards trial or a hearing. And if it does that, then usually what has been talked about in mediation shouldn't be brought up at trial. You're not going to call the mediator as a witness, and any offer that you made during mediation shouldn't be used to kind of pin you into that position. You still can ask for whatever relief it was that you asked for initially in your petition. Okay, so let's say mediation didn't work out, unfortunately. Next, you end up having to have a trial or a hearing. A judge is really going to want you to figure out these arrangements on your own if you can. They'll give you plenty of opportunities to do this, and their feeling is that if the judge has to make a decision, it takes the control away from the parents, and oftentimes the result is that no one is happy with the decision. Of course, that's not how it plays out in every case, but oftentimes, the judge just isn't as involved as the parents are, and so they're less able to see the nuance and make a decision that's going to work for everyone. If the parents can work out an agreement or an arrangement that's satisfactory for everyone, then that's great. However, that being said, if you're in an abusive situation where there is a differential in the control power dynamic, then it's probably best to take the power and the control away from that abusive person and put it in the hands of the court, a neutral third party. That's what a hearing is for. So there definitely are situations where it's beneficial to have a judge make a decision about your case. So just thinking through the pros and cons, before you either file a petition in the first place or agree to a settlement. There's always an option to have a trial if need be. At that trial, you're going to present your evidence and your witnesses. You're going to want to have a clear outline of the case that you're presenting, and your theory of the case, your story. Make sure you understand where you're going with it, how you're proving what it is that you need to prove with either witnesses or evidence or your own testimony, so that way the judge can grant you the relief that you're looking for. If you don't give the judge a reason to grant you the relief, then it makes it very difficult for them to do that. One helpful way that you can sort of outline and prepare for the trial is to use your state's best interest factors that we discussed earlier. You can go down the list and you can pick out, okay, here's how I can show that I've been the primary caregiver. I have my sister-in-law has seen me raising the child, and whenever she comes over, I'm the one who's taking care of the child. She knows that the other parent is out with friends all the time, or whatever the case may be, and can testify to that. So then, you have that best interest factor, and you have a piece of evidence to show why you are the suitable parent for that factor, and you can go from there, each one, down the list. So that's one way that you can get organized and try to present your case. Those best interest factors for your state are on our womenslaw.org website. So if you go to the custody section and then pull your state down from the drop-down menu, how a judge might make a decision, then you'll find there the best interest factors are usually listed out. So you can find them there and use that to create your outline. So in terms of the trial itself, usually the petitioner is going to be the one who goes first and presents their case. They'll do this by, like I said, calling witnesses and presenting evidence and explaining why they should be granted the relief that they requested in their petition. Once they've concluded, then the other parent will have a chance to present their case, and all the while, the other party will be able to question the witnesses that are brought by the parent who is presenting their case. So when the petitioner is presenting their case, then the respondent will be able to cross-examine their witnesses. If the petitioner himself or herself testifies, then the respondent or the respondent's lawyer will have a chance to cross-examine the petitioner, and vice versa when the respondent is presenting their case. We do have some information about how to do this on our Women's Law website. So again, you go to Preparing for Court and go down to At the Hearing. And so when you're in the At the Hearing section, it talks about how to present evidence, how to question witnesses, how to cross-examine, how to object, what you can object to. All of these things are going to be important as you're preparing for your trial and as you're going through the actual trial. Okay. And then if there is an attorney for the child, they'll also have a chance to present evidence. So after the petitioner or respondent present their case, then the attorney for the child can present his or her case. And when all that's concluded, the parties may have a chance to present some closing arguments. The judge could say, please present your closing statement, which is just kind of a summary of the evidence that you presented and the relief that you think is warranted and should be granted based on that evidence that you presented. The judge may not ask for closing statements, but if so, it's best to have at least some outline of a statement in mind. That way you can go ahead and do that if the judge asks for it. All right. Once that happens, the judge will make a decision about your case. It might be there at the same day on the trial. The judge could issue a decision from the bench and just say, "Here's what's going to happen," and then issue a written decision later. Judge could instead take some time to think through the evidence. They could do some research on their own if they had to, if there's complex legal issues involved, and then the judge would issue a written decision, um, outlining the custody arrangement and their findings. Once that happens, if you are not satisfied with the decision, then you may have a few options that you can pursue. One of them could be to motion for the judge to reconsider the decision. This is kind of a difficult one because judges don't like to overturn their own decisions. So you're going to have either a new piece of evidence that was unavailable at the time of trial, or some other extreme circumstances for a judge to think about overturning their own decision. Another option would be to file an appeal of the case. An appeal is when your case is moved to a different judge to review the decision of the lower court judge. So the appellate court is not going to hold a new trial. They're just going to look at the evidence that was entered. They'll read through the transcripts of the testimony, and they'll decide, A, was the judge's decision correct? And B, was there any kind of procedural defects or issues that may have impacted the result of the trial? For example, if there's a piece of evidence that was in question and maybe you objected to it, and the judge overruled your objection and entered the evidence, and that was a material or very important piece of evidence, and then the judge based the decision on that, the appellate court might decide that your objection should have stood and that the piece of evidence should have been excluded, which then would have changed the whole outcome of the trial. And it would, so then the appellate court could reverse the decision. They could remand it, or they could just say, based on this, we're going to reverse it. The other option is the lower court, the appellate judge could decide that the lower court judge ruled correctly. And then that would be that. So appealing is an option. It can be a very complex process. So if you can get a lawyer for this, then that's probably the best option for you. I know it's not always easy or accessible for folks, but really having a lawyer is going to be helpful. There are organizations that may help people with appeals. You can find that on our website. One of them is called DB Leap. If you're going to try to do it on your own, you can find some general information in our Preparing for Court section, like I mentioned earlier. Okay, so let's say that you have an order and it's been in place. You haven't had to appeal. Maybe you did, but anyway, the order is what it is. At some point, you may need to, the order may not be working any longer. There may have been some kind of a change that occurred that made it so that the child is no longer satisfied with the arrangement, or maybe you or the other parent aren't satisfied with the arrangement, and there has to be a change. So once that final order is issued, that order is the controlling order until it's changed or modified. Usually to change this order, you would have to file a petition with the court that issued the original order and allege that there has been a substantial change of circumstances since that final order was issued. The circumstances could be something like the child is older now and has different wishes. Maybe the child's really actively involved in sports and so interferes with visitation on some weekends. That could be a change in circumstances. It doesn't necessarily have to be earth-shattering. It can be something that is just a major enough change where the visitation or the custody arrangement has been affected. It could be something larger. It could be that one of the parents is getting married or wants to move, that kind of thing. But it doesn't necessarily have to be. But whatever the change is in your specific situation, you're going to want to make sure that you specify that in your petition to change the order. And you also want to make sure that you let the judge know how it is that you'd want to see the order changed or modified. The judge is, maybe going to have a hearing, but the parties may be able to reach an agreement without a hearing. It all just depends on kind of the past relationship of the parties and how that relationship is going. If the case does go to a hearing, then the judge is going to be looking for, number one, is there a substantial change of circumstances to support a modification? And number two, is the change in the best interest of the child? And then if so, then the judge may grant the modification. I also want to talk a little bit about what happens if a parent doesn't follow the order once it's been issued. In those cases, let's say, for example, one parent is not allowing visitation for the other parent, or if it's a joint custody arrangement, which is 50-50 type placement, maybe one parent is refusing to do the exchange, or is late all the time, or there's some other violation of the court order. In those situations, then a parent who is the aggrieved parent may be able to file a motion for contempt. It could be a violation petition, it could be an enforcement petition. It depends on your state. I'm going to go with motion for contempt just for clarity's sake. So they would file the motion for contempt, ask the judge to make sure that the other party follows the order, and potentially even punish the other parent for not following the order. There could be a variety of penalties that the judge may employ to try to get the other parent, the parent who's found in contempt, to obey the order. There could be some financial penalties. They may be ordered to have to provide makeup time with the other parent. If there's repeated violations, the judge might even change custody. The parent who is violating the order may lose custody if they had it. So there are some consequences for not following a custody order, and if that happens to you, then you may want to talk to the court clerk or talk to a lawyer about potentially filing a motion for a contempt or a contempt petition, violation petition, whatever the phraseology is in your jurisdiction. So that's it for me for today. I want to say thank you for watching. I hope it was helpful. I hope you gathered some useful information. If you are involved in a custody process or are going to be, then we do have other online information clinics available on this topic that should be useful for you. If you still have questions after watching these and after looking at our Women's Law website, then you may want to write into us on our email hotline. We take questions on there, and we can provide legal information. That's, we can't provide advice, but we can provide information and referrals based on your situation. So feel free to drop us a question on the hotline if you have anything further. All right, well, thank you.